Now it is my pleasure to introduce our second speaker, Claudia Sandei. Claudia is an associate professor of company law at the University of Padua, a professor of youth financial and technology law at the University of Hong Kong, and also the director of the Innovation and Technology Law Lab. Claudia is the author of 2 books on the impact of technology on listed companies, and of many articles on intersection of technology, business, and financial law. The title of Claudia's presentation, truly fascinating, is Cyberattacks and Directors Liability. Claudia, welcome. We are excited to hear your insights on the intersections of cyberattacks and the liability of directors. Please, Claudia, the floor is yours.
So, thank you very much for this kind invitation. It's a really pleasure for me to be here to share some initial thoughts on this topic, which is going to become viral, I think, because there are some important decisions in the US we are going to consider that shows that the topic is really growing in importance all around the world. So the topic is that as cyber attacks are growing in importance, we need to assess whether directors should be or could be held personally liable. And so if derivative actions in particular could be forced against them. So just to start, there's the background we are working in, and in Europe, I have considered the Europe and the European legislation first. The statistics says, the research says that 22% of enterprises has suffered, experienced this kind of incidents, and that this the number is going to increase because of many issues that are here summarized by our cybersecurity authority, ENISA. And the most important problem is that we are suffering some ransomware attacks, and also the war in Ukraine seems to be a factor that is pushing up the number of attacks. So I think that it's a very complicated it's very complicated for corporation, even because, as again this reports shows us, is that there are no sectors which are out of danger. All the sectors can be affected by this, and also big companies like small companies are affected by cyber risk. And the forecast is that it will continue to grow because of the massive use of IT and AI applications, and IoT in particular, because we use those kind of devices, but they are not very secure, and so a lot of attacks can start from IoT devices. So our European authority for cybersecurity is very worried about the security of corporations, and they have some devastating effects. Someone estimates that there are at least 57 different effects. I think that just 6 is okay, and they are reputational, economic, physical, digital, and social. Of course, we are very worried about economic and reputational, but also the social impact with the development of ESG policy. I think that should be taken in account by our corporations. So to come to our research question is, what are the board duties? And I will start with this quotation from the UK National Cybersecurity Center, and they are, just straight on, and they say the board is responsible. It seems to be every board in every situation is responsible for ensuring that risks to delivering the strategy are correctly, adequately identified, evaluated, mitigated, and blah, blah, blah. And the board members don't need to be technical, but you need to know enough. So those are the 2 pillars of this document. And according to me, it's a little too straightforward. I think some distinctions should be made. And so I will try to share with you my approach. So I think that we have to distinguish. The first hypothesis or the first case is when the lack of monitoring results in an infringement by the corporation. For example, if I don't monitor my cyber risk and I suffer a data breach and some personal data are stolen, in that case, the GDPR says that I have, as a company, the duty, the legal duty to prevent this kind of attacks. And the same is written in NIS 2, which is a directive from the European Union, which is about the cybersecurity requirements that some big corporation or essential corporation should comply with. And finally, the Digital Resilience Act, which is a regulation which is not still in force, also for financial institutions, asks financial institutions to have some cyber measures in force, to have some cyber compliance. So I think that if we are in one of these situations, that the company has a duty to have cybersecurity risk management, I think that, of course, the management body should be held liable because there is an illicit. So they went contra legem. Okay, so this is the Article 4 of the DORA regulation, which is just for financial entities. And Article 4 stands for that financial entities shall have, it's a legal duty, some internal governance measure. The management body shall do something, and the management body bear the financial responsibility. And they have to be trained. It's a legal duty again, to be trained, to be skilled. And the same is in this directive on security of networks. So just for big corporation or essential corporation, the member states shall ensure that essential and important entities approve the cybersecurity risk management. They have to oversee and they can be held liable. And they have to be trained and to have some skills again. And what's around the world? Well, even in the United States, the Security and Exchange Commission is working on a proposal to introduce some requirements which are very similar to the DORA ones. And so I think that all around the world, we are working all around the world for achieving the same result. Financial entities are very important, and we can ask them to be more aware of this kind of risks. But in the US, there is also another proposal which is very important, because they are going to set down some rules applicable to all public companies. We don't have in Europe still this kind of requirements for public companies, just for the financial companies or essential companies in the sector of transportation and health and so on, but not for all companies which are listed in capital markets. And here again, there is the focus is on the board duties and the board skills. They have to disclose a lot of policies about cybersecurity. So it's not like in the DORA or in the financial entities sex proposal to do something, but to be transparent, to communicate better to the market what's going on about cybersecurity. And in Australia, again, in 2021, a public consultation was published. A lot of comments came, and they are looking how to enhance cybersecurity through governance. And they are still struggling about within these two options. They haven't yet decided what to do. So to adopt a voluntary governance standards like in the US. So if you have a standard, you have to disclose it to the market, or if it would be better to have mandatory standards. In Europe, as I said, mandatory standards are just concentrated, they just concern some entities. financial entities, essential entities, and the protection for people. So in the second hypothesis, where we don't have, if we don't have any legal duty, what can we say about the board's responsibility? So I think that in this case, we need to apply the business judgment rule. There is nothing different from this, or the Caremark tradition or opinion, which is the business judgment rule in this area of monitoring in the US. So I think that the only way to address this question is not they are liable, but it depends if the business judgment rule is passed or not. And there are two decisions in the US which are very important. We need to consider. The first one is SolarWinds, and it was decided in September 2022. And in this decision, the Court of Delaware said that despite cybersecurity is very important, it is a critical mission. So despite this importance, they dismissed the derivative action against the SolarWinds board because they didn't violate any laws. So it seems that when you have not a legal duty, you cannot be recognized as guilty for the breach of the duty of loyalty in itself. And the second decision is that one from Marriott. And here the court says that we need to demonstrate that the board's deliberate failure to act, and so that there was the voluntary to favor the cyber attack. So, for example, you have a system of red flags, and you don't attend at them. So to conclude, I think that we can say that this 92% of businesses in Europe that use at least one ICT measure, and not all the measures you have, they are guilty. I think that we have to balance the size of the company and the critical or non-critical issue of technology to decide if the board is liable. To conclude, I think that with the transposition of NIS2, many companies' directors will be exposed to the risk of resulting personal libel, which will become true after 2034. And that European Union should consider the foreigner's proposal to extend some legal obligation to cybersecurity beyond this perimeter, and that it is quite difficult for shareholders to get some compensation when the board fails to consider cyber risk in an adequate way. So it's very complicated to demonstrate that the business judgment rule has been failed in cybersecurity. Of course, if company directors want to prevent this kind of risk in any case, they should come and they should consider the standards set down by our European authority. I think that this should be a very clever and duty, how can I say, a very good behavior in order to avoid any responsibility. Thank you so much.
Thank you very much, Claudia. Really stimulating and great presentation on directors' liability for cyber attacks. Thanks also for your critical analysis of the current framework and future proposal. We look forward to discussing this topic during the Q&A session.